estate planning for when we die isn't always the most comfortable or popular dinner table topic, but our next guest says it is important for everyone to have their checks and balances in place well in advance. For more on common mistakes to avoid, we're joined by Sandy Abley, wills and estate lawyer with Onyx Law Group. She's also a certified financial planner and money coach at thewealthdoc.ca. Thanks so much for joining us today.
It's my pleasure to be here.
So I guess where we should start is what happens if you die and you don't have a will? What's the sort of worst case scenario here that we want to avoid?
Well, in every province, there are rules and laws about what happens when you die without a will. And we've seen that happen. You know, celebrities, there are cases where they pass away and they don't have a will. And sometimes conflict occurs from that. So when you die without a will, oftentimes the law will suggest that if you have a spouse, that your estate will go to your spouse. If you have a spouse and children, then the estate will be shared between your spouse and children. And if you don't have a spouse and children, they'll go to your parents. And oftentimes this is not desirable. If you have children and a spouse, you often want your property, your estate to go to your spouse because there can be unintended tax consequences otherwise. Or you might have charities that you really support, and those charities that you support won't receive any assets from your estate. So it's important to think about what you want to happen when you pass away, and the will are a set of instructions that will allow your wishes to be met.
So if someone is going to get a will for the first time, or maybe even just to update one that they did many years ago,
Yes.
and they're thinking about what they need to prepare in order to do this, what are some of the things that people should be either gathering or considering in advance?
Well, certainly I suggest that you pull out your will at least once a year. I suggest to my clients, look at it when you're doing your taxes. That's a good time. You're going to be paying a legal advisor to go through your documents. They often charge you an hourly rate. So before you come in, you should think about key people that you want to appoint as part of your will and your estate plan. So for example, you want to appoint an executor. That's the person who's going to be in charge of your estate when you pass away. They're going to pay down debt, file your tax return, sell assets, distribute your assets. And then you want to think about, well, who will be the backup executor in case this person is unavailable at the time of your death? You might want to think about creating a trust for maybe a person who is disabled that you're taking care of. Who will be the trustee of this trust? Who will be the backup trustee in case this person is unavailable? If you have young children, you might want to think about, in advance of your meeting, appointing guardians and a backup guardian as well. When I talk to people about guardians, they'll often say, well, I think I'm going to appoint my sister and her husband. And I usually caution against that because I don't know if 4 or 5 years down the line, if they'll still be together. So I suggest that they appoint a guardian and appoint that one key person that they want to be raising their children, and then a backup guardian.
Is there a certain point in your life where, I mean, a will is something you absolutely have to have, for in your opinion, and the difference between doing sort of a basic, maybe online version of that will, or like you mentioned, going to a lawyer and having something worked up professionally for you. Is it sort of different stages of your life potentially, or just your financial circumstances?
I think it's different stages, but also how complex your life is. I've met young people who have designed apps, who've created businesses, and their life is really complex, even though they might not have children. I need to integrate, their shareholders agreement, maybe a potential marriage agreement with their estate planning. What I try to suggest to people is think about hatches, matches, and dispatches, right? Review that will when something significant in your life happens. And a hatch doesn't have to be a child being born into the family. It could be you've hatched a mortgage or you've hatched a new business, and contemplating everything that might be be a consequence if you die, or perhaps if you are incapacitated. I think as part of your estate plan, it's really important not just to think about the will as your entire estate plan. There are many components to your estate plan, and that includes incapacity planning. What happens if you are in an accident and you're in a coma, or you are going through an illness and you're in surgery? Who is going to be looking at your financial affairs when you're still alive, but you just can't speak on your behalf? So it's a lot of things to think about. And sometimes people think I can create my own will, but sometimes you don't know what you don't know. And I'm just going to give a really quick example. I had a sad situation where a person died relatively young with very young children. When he first started working at his company, he had opened an RRSP account, a savings account that his company contributes to. At that time, he wasn't married. So he appointed his sibling as the beneficiary of his RRSP. The years passed, that investment grew, and when he passed away, that money, which had a lot of tax consequences, went to his sibling, not to his spouse, who is taking care of his children, and she ended up paying the tax bill. So sometimes when you are doing your own estate planning or your own will, you're not thinking about all the other components and the ultimate consequences to your loved ones.
Both of those certain things in life, like I mentioned before the break, death and taxes at the same time there, dealing with both of them, that would be quite a challenge that person would have been up against, I'm sure, emotionally too as well, which is part of it, right? Having this sort of plan laid out in advance so that the people left in your life aren't having to deal with this stuff in a challenging way. You mentioned also provinces have some different rules. So if you're moving, that would also be a time that you might need to speak with somebody in the new area that you're moving to make sure things are still in line the way you hope that they are.
Definitely. I'm based out of British Columbia, and we have a lot of people who like to retire to British Columbia from Alberta. Alberta does not have a large probate fee on death. They just have a small flat fee, and we have in British Columbia a 1.5% probate fee. So if your estate is worth $1 million, your estate's going to be paying $14,000 in probate fees. And then, if it's worth a lot more, you'll be paying a lot more for that. So we also have litigation occurs more often in British Columbia when it comes to estate litigation. And so when you're moving from a province such as Alberta to British Columbia, as an example, it's important to make sure that you review your documents with your lawyer in your new jurisdiction to make sure that it all works in the new jurisdiction. Maybe there are no changes that need to be made, but maybe there are some rules that you can take advantage of in the new jurisdiction that you weren't aware of.